I'm Walter Isaacson of the Aspen Institute. I'm with Jeffrey Rosen of the National Constitution Center talking about the Constitution. Let's look at Article 3. That's the one that sets up the judiciary. It says the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. So what are they doing here, making a third branch of government?
They are making a third branch, and they're putting the Supreme Court at the head of that branch, and it's fully equal to the other two. On the other hand, Alexander Hamilton said that the judicial branch would be the least dangerous branch because it had neither purse nor sword. And I think it's fair to say that the framers spent less time worrying about the nature of the judiciary than they did about Congress and the president.
In Section 2, they enumerate what cases the courts are supposed to look at. It seems pretty narrow. Why is that?
It is. Look at this. The original jurisdiction of the Supreme Court, that is the cases they have to hear whether they want to or not, is a relatively small category of pretty technical cases affecting ambassadors, maritime jurisdiction, controversies between two states. All this means that the Supreme Court has incredibly broad jurisdiction and discretion to hear or not to hear whatever cases they like, and the number of cases they have to hear is pretty small.
Well, the main thing we figure that the Supreme Court does is it reviews laws passed by Congress and actions of the president to see whether or not they're constitutional. But I'm not sure I see that in Article 3.
Well, that's a very good point. Where does this power of judicial review, as it's called, come from? Judicial review, the power to strike down laws that violate the Constitution.
So when we say the Affordable Care Act, it seems unconstitutional, let's go to the Supreme Court, see if they'll strike it down. That's what you mean by judicial review, right?
Exactly right. Judges taking a law passed by Congress, comparing it to the Constitution, and saying whether or not it passes muster. So you're right that the words judicial review don't appear in the Constitution. But in fact, the power was deeply rooted in English common law. There were cases from the 1760s where courts had struck down laws that violated common law. But really, the theory comes from Alexander Hamilton in Federalist 78. Here's what Alexander Hamilton said. He said that when there's a conflict between the will of the people, represented by the Constitution, and the will of the people's servants, represented by laws passed by ordinary legislators, then judges should prefer that of the master to that of the servant, that of the principal to that of the agent. So the entire theory of judicial review, expressed in this idea of popular sovereignty, is based on the notion that the Constitution stands for the will of the people, and an ordinary law passed by Congress just represents the will of our representatives.
You just invoked the Federalist Papers, and that was sort of the documents that Madison and Jay and Hamilton and others worked together on to explain what the Constitution meant. So when we're interpreting this Constitution, does it make sense to go back to those papers? Is that why you did so?
It's a great question, and I think the answer is yes. It's certainly relevant to ask what Madison and Hamilton and Jay wrote in the Federalist Papers, not only because they were such important members of the Constitutional Convention and because Madison is considered the principal framer of the Constitution, but because the Federalist Papers were the public documents that we, the people who ratified the Constitution, read. And when we try to figure out the original understanding of the Constitution, we're less interested in what James Madison thought than what the people who ratified the Constitution thought, because it was the ratification that breathed life into the Constitution and made it fair for us to consider it as representing the people's sovereign will. So that's why the Federalist Papers are important.
So what was the case, or when did we finally get it settled, that when there was a dispute between two branches of government, it would be the Supreme Court who had the final word?
Well, the case was Marbury versus Madison, and it was decided by John Marshall. And it was such a fascinating case because it was a political conflict between Thomas Jefferson and John Marshall that could have meant the end of the judiciary. First of all, Marshall and Jefferson, who were distant cousins, hated each other. They generally...
That's what happens to two gentlemen from Virginia, right?
It's very tough, and I think there was some family bad blood. They had this family feud, and essentially, here's the situation. In the waning days of the Adams administration, John Adams and his Secretary of State, who happened to be John Marshall, had stood up all night signing these commissions for various federal officials. Marshall, as Secretary of State, was supposed to deliver the commissions, but he forgot to do it. He was busy with other stuff. So then Thomas Jefferson gets into office, and one guy who was supposed to have gotten his commission, Marbury, says, "I'm entitled to my commission. Supreme Court, force President Jefferson to deliver the commission." So here's the dilemma. If John Marshall, who's now sitting on the Supreme Court, and by the way, should have refused to hear the case since he'd been responsible for the mess that led to it in the first place, If Marshall says to Thomas Jefferson, deliver the commissions, Jefferson's going to ignore him and reveal the court to be a paper tiger. If Marshall backs down and refuses to say he has the power to do anything, he'll look weak. So he exercises an act of judicial jujitsu, which in retrospect is sort of dazzling in its chutzpah, to mix my metaphors.
Well, definitely brilliant.
Absolutely. Marshall says, yes, Marbury's entitled to his commission. It should have been delivered, and therefore, usually for every right, there's a remedy. However, and here's the kicker, the federal act that authorizes Marbury to receive his commission itself is unconstitutional because it exceeds the original jurisdiction of the Supreme Court that we just read together. So it's a temporary victory for President Jefferson, who doesn't have to deliver the commission, but a long-term victory for federal power because Marshall has established this power of judicial review. It's an incredible example of long-term thinking.
And so this is 1803, about 20 years after the Constitution is done, and that really sets in stone that we have three branches that are pretty much co-equal, because even though the judiciary doesn't do quite as much, it has the final word when there's a dispute.
It does have the final word, John Marshall said. It's a constitution we're expanding, and at the very least, all three branches of government have to agree that a law is constitutional before it can go into effect.
Jeffrey Rosen, thank you.
Thank you.